Mr. Chilson, you worked at the FTC, is that right?
That's right.
Chief Technologist at the FTC, I think was your title?
Acting Chief Technologist, yes.
Yeah, and you focused on, I'm looking from the bio here, the economics of privacy, blockchain-related issues. Is that accurate?
That's correct.
Work for the commissioner.
Yes.
Yeah, and you're an attorney as well?
I am, yes.
You understand the Bill of Rights, the Constitution, all the things they teach us in law school and all that, all those important. Is it appropriate for the FTC to ask an American company, the journalists, that they have communicated with?
I don't think so, sir.
I don't think so either, but that's exactly what happened at the FTC. Mr. Bedoya works at just a couple years ago. They sent a letter to Twitter after Mr. Musk had purchased the business and said it's recently reported that Twitter has been providing certain third-party journalists information. And they named the journalists. Barry Weiss, Matt Taibbi, Michael Schellenberger, Abigail Schreier. They name the journalists, and they say this: identify all journalists and other members of the media to whom you've granted any type of access to the companies of communication. Is that appropriate?
I don't see what it would have to do with most of the types of actions that the FTC would bring.
Seems to me it's totally getting at, violating the First Amendment, freedom of the press. You got a right as a company, people in a company, to talk to journalists. And yet the FTC wants to know any and every journalist you've communicated, named 4 specifically, and wants to know any others you've talked to. What do you think, Mr. Chilson? Pretty bad stuff that was going on there?
Yeah.
Let me ask you this then, too. They also they wanted to know every reason why Twitter terminated former Twitter employee Jim Baker. Do you know anything about that, Mr. Chilson? Why they'd be asking about that guy?
I don't know much about that, and I don't know why they would.
I got my hunches. Jim Baker was the general counsel at the FBI when the FBI was doing all the crazy things, going to the FISA court, getting warrants, spying on presidential campaigns. He then goes to work at Twitter. Mr. Musk buys Twitter and says, I'm going to get rid of this guy. And now the FTC wants to know why? I find that strange, too. Every journalist you've talked to and why you got rid of Jim Baker. Let me ask you another one. Ernst & Young was named the assessor in the consent decree focus between the FTC and Twitter. The specific assessor was a guy, David Roque. He testified under oath and said, quote, that if Ernst & Young did not include negative findings against Twitter, the FTC raised the specter that it would create other challenges for Ernst & Young over time. Does that seem to be the kind of communication that should be going from the FTC to the assessor at Ernst & Young, Mr. Chilson?
It seems like a form of soft coercion.
Yeah, is that accurate, Mr. Bedoya? Did you guys do that? Mr. Roque, again, this is under oath in the case. Is that what happened at the FTC? Why would you tell Ernst & Young, you better find out the right thing, you better find something negative against Twitter, you may not get business with us over time?
Thank you, Mr. Chairman, for the question. I'm not familiar with that particular communication, and so given that I am under oath, I don't want to give a wrong answer here.
So are you disputing whether it happened or not? It's a court filing.
No, sir, I'm not disputing that. I'm just saying I'm not familiar with that particular communication, and like you said, I'm under oath.
I'm asking you if it's appropriate or not. It happened. Here's what he said. If Ernst & Young did not include negative findings against Twitter, the FTC raised the specter that it would create other challenges for Ernst & Young over time. You hire Ernst & Young to be assessors in these kind of consent decree arrangements all the time. You can see the obvious threat there. I'm just asking if that's appropriate.
Mr. Chairman, who is saying that statement? Who's writing it?
Documents that David Roque communicated in the court that we have that point this out.
Forgive me, Mr. Rell is an Ernst & Young executive?
Yeah, he's the assessor you guys hired.
And he was, I'm sorry, I take this very seriously, and so what I would ask is if you submit it for the record, I'll take a good look at it and give you a full and complete answer, but I'm not familiar with the context of the statement.
Why'd you have to know about Jim Baker? Why he was terminated? Companies are allowed to fire people.
Mr. Chairman, I did not sign those CIDs. I did not sign those subpoenas, and so I don't know the exact circumstances surrounding that individual.
Okay. No comment there. All right, Mr. Coniglio, Mr. Bedoya raised 3 concerns earlier, and I just got a few seconds, but I wonder if, and any of you 3 can comment on this. 3 warnings that he pointed out: vertical integration, AI keeping private data private, and then the surveillance concern. Do you have a different perspective on those 3 concerns, or tell me what your thoughts on the 3 warnings he laid out in his testimony?
Thank you for the question. I can start with the first one about AI partnerships and vertical integration and anti-competitive conduct. I think that the concerns about foreclosure, which are the typical anti-competitive harm that you think about when you go with vertical integration, are certainly very premature at this stage. We see robust competition at the foundation model level and the cloud level, which suggests that a vertical integration between, let's say, a cloud company and a foundation model is unlikely to result in any sort of exclusionary conduct. With respect to the partnerships and sort of a horizontal, so to speak, reduction of competition between, let's say, a big tech firm that may have a partnership, and the idea being that because they're investing in these companies, they're less likely to compete. Again, I think it's unlikely that that's going to result in a substantial lessening of competition, again, because of the robust competition that exists at the foundation model level, but also because of the pro-competitive benefits that these partnerships can have, specifically providing AI foundation model startups with the sort of patient capital they need to grow sustainably and actually innovate faster.
Okay, good. I know I'm out of time, but can you talk about the privacy issue real quick too? Any one of you want to talk on the privacy? I mean, I have concerns about this whole facial recognition and stuff and some of the examples that Mr. Bedoya gave in his testimony. So give me your quick thoughts on that, and then I'll be happy to yield back to Mr. Chairman.
So in many ways, the privacy issue in artificial intelligence, especially these deep learning models, is much more complicated than it is in the form of social media. And so when you train these models, what you get is something that does not have any of the actual training data in it. So you can never look into a model and see the specific training that was in there. So the privacy implications here are ones more on the inference side and not about actual data being in these. Okay. And so it's much more like remembering that something happened, but not remembering it precisely. And therefore, I think I think the privacy concerns are less.
Gentlemen.